A. Importance of business contracts. Business contracts are an essential part of any business transaction, big or small. These legal documents outline the terms and conditions that the parties involved agree to follow. They provide a framework for the parties to understand their rights and obligations in the business relationship. The purpose of a business contract is to protect both parties, minimize misunderstandings, and avoid conflicts. When drafted correctly, business contracts can help establish trust, reduce risks, and facilitate successful partnerships. B. Purpose of the video. The purpose of this video is to provide a comprehensive guide on the do's and don'ts of business contracts. It will cover everything from identifying the parties involved, defining the terms and conditions, specifying the scope of work, payment terms and schedules, termination and dispute resolution clauses, and common mistakes to avoid. By the end of this video, viewers will have a better understanding of what makes a good business contract, what to avoid, and how to ensure their contracts are legally binding and enforceable. This video is ideal for entrepreneurs, business owners, managers, and anyone who wants to learn more about business contracts. Dose of business contracts. A. Identify the parties involved. One of the essential elements of any business contract is identifying the parties involved. The contract must clearly state the names, addresses, and contact information of both parties, along with their roles and responsibilities. This information is crucial as it helps to avoid any confusion about who is responsible for what, and it helps to ensure that the contract is legally binding. B. Define the terms and conditions clearly. A well-written business contract should define the terms and conditions of the agreement clearly. It should outline the specific obligations of each party, the timeline for completion of the project, the expected quality of work, and any other details relevant to the agreement. Clear and concise language is essential, and any technical or legal terms used should be defined within the contract. C. Specify the scope of work and deliverables. The scope of work outlines the specific tasks and deliverables that the parties agree to complete. It is essential to specify the scope of work and deliverables in the contract to ensure that both parties have a clear understanding of what is expected. The contract should also specify the timeline for completion of the work and any milestones that must be met along the way. D. Include payment terms and schedules. The contract should clearly outline the payment terms and schedules. It should specify the amount to be paid, the method of payment, and the time frame for payment. Payment schedules can be tied to the completion of specific milestones or a schedule agreed upon by both parties. Including payment terms and schedules in the contract can help to avoid any misunderstandings or disputes over payment. E. Add clauses for termination and dispute resolution. Termination and dispute resolution clauses are important elements of any business contract. The termination clause should outline the circumstances under which the contract can be terminated by either party, the notice required for termination, and any consequences for terminating the contract. The dispute resolution clause should outline the procedures to be followed in the event of a dispute between the parties, such as mediation or arbitration. In summary, a well-written business contract should clearly identify the parties involved, define the terms and conditions, specify the scope of work and deliverables, include payment terms and schedules, and add clauses for termination and dispute resolution. By following these doses, businesses can ensure that their contracts are clear, concise, and legally binding, which can help to protect their interests and avoid any disputes. Don'ts of business contracts. A. Use vague or ambiguous language. Using vague or ambiguous language in a business contract can lead to misunderstandings and disputes down the road. The contract should be clear and concise, using language that is easily understood by both parties. It is essential to avoid using legal jargon or technical terms that may not be understood by all parties. If necessary, the contract should define any terms or phrases that may be unclear. B. Rely on verbal agreements. Relying on verbal agreements can be risky as they are difficult to prove in court. Any agreements or promises made verbally should be included in the written contract. This ensures that both parties have a clear understanding of the terms and conditions of the agreement and helps to avoid any disputes down the road. C. Rush into signing the contract without reading it thoroughly. It is important to read the entire contract thoroughly before signing it. Rushing into signing the contract without understanding its terms and conditions can lead to serious problems down the road. It is essential to take the time to read and understand the contract fully, asking questions and seeking clarification if necessary. D. Assume that a standard template will suffice for every contract. Every business contract is unique, and a standard template may not be appropriate for every situation. It is essential to tailor the contract to the specific needs of the parties involved. Using a standard template without making necessary modifications can result in missing important details or including irrelevant terms. E. Ignore legal advice and counsel. Seeking legal advice and counsel is important when drafting a business contract. Ignoring legal advice and counsel can be risky and can result in legal problems down the road. A lawyer can help to ensure that the contract is legally binding and enforceable, and can advise on any potential legal issues that may arise. In summary, businesses should avoid using vague or ambiguous language, relying on verbal agreements, rushing into signing the contract without reading it thoroughly, assuming that a standard template will suffice for every contract, and ignoring legal advice and counsel. By avoiding these common mistakes, businesses can ensure that their contracts are clear, legally binding, and enforceable, which can help to protect their interests and avoid any disputes. Common mistakes to avoid. A. Not including essential details in the contract. Failing to include essential details in a business contract can lead to misunderstandings and disputes. It is important to include all relevant details, such as the scope of work, deliverables, timelines, payment terms, and termination clauses. The contract should be comprehensive and should address all potential issues that may arise during the course of the agreement. B. Failing to update the contract regularly. Business contracts should be updated regularly to reflect any changes in the business relationship or legal and regulatory requirements. Failure to update the contract can result in outdated or incorrect information, which can lead to disputes down the road. It is important to review and update the contract regularly to ensure that it is accurate and up to date. C. Ignoring the legal and regulatory requirements. Business contracts must comply with legal and regulatory requirements. Failure to comply with these requirements can lead to legal problems down the road. It is important to seek legal advice and counsel to ensure that the contract complies with all relevant laws and regulations. D. Overcomplicating the contract language. Using overly complicated language in a business contract can make it difficult for both parties to understand. The contract should use simple and clear language, avoiding legal jargon or technical terms that may not be understood by all parties. It is important to use language that is easily understood by both parties to avoid misunderstandings and disputes down the road. E. Allowing the contract to be one-sided. A business contract should be fair and equitable to both parties. Allowing the contract to be one-sided can lead to disputes down the road. Both parties should have a clear understanding of their rights and obligations under the contract. It is important to ensure that the contract is balanced and does not unfairly favor one party over the other. In summary, businesses should avoid common mistakes such as not including essential details in the contract, failing to update the contract regularly, ignoring the legal and regulatory requirements, overcomplicating the contract language, and allowing the contract to be one-sided. By avoiding these mistakes, businesses can ensure that their contracts are comprehensive, legally binding, and fair to all parties involved. In conclusion, a business contract is a legally binding agreement that is essential for any business relationship. To ensure that the contract is comprehensive, legally binding, and fair to all parties involved, businesses must follow the do's and don'ts of drafting a contract. The do's include identifying the parties involved, defining the terms and conditions clearly, specifying the scope of work and deliverables, including payment terms and schedules, and adding clauses for termination and dispute resolution. On the other hand, the don'ts include avoiding vague or ambiguous language, not relying on verbal agreements, not rushing into signing the contract without reading it thoroughly, not assuming that a standard template will suffice for every contract, and not ignoring legal advice and counsel. It is important to seek legal advice when drafting a business contract. A lawyer can ensure that the contract complies with all relevant laws and regulations, is legally binding and enforceable, and does not contain any clauses that may lead to legal disputes down the road. We encourage businesses to review and update their existing contracts regularly to ensure that they reflect any changes in the business relationship or legal and regulatory requirements. This will help to avoid misunderstandings and disputes down the road and will ensure that the contract remains fair and equitable to all parties involved. In summary, By following the do's and don'ts of drafting a business contract, seeking legal advice, and reviewing and updating existing contracts regularly, businesses can ensure that their contracts are comprehensive, legally binding, and fair to all parties involved.